Yes, Mr. Hadley.
Yes, my lady, my lords, I'm coming on now to the third of the 6 headings I outlined. That's the meaning of the term proceedings as it's used in the County Court Act. Before I come to the Act itself, just briefly, 2 authorities which acknowledge that the term proceedings is not one that's used consistently in the law. First of all, Claimant and Perrett have 7 in the authorities bundle. Supreme Court decision from 2017. This was about the recoverability of a success fee under conditional fee agreements. And
Sorry, I've got the wrong tab number.
Did you say 7?
17.
Oh, yes. I was. Creamer Holdings didn't seem to be about that. Hold him. Thank you.
Yeah, this was a case about the recoverability of a success fee under a CFA, and it turned on the meaning of proceedings in section 44 of LASPO. The claimant was seeking to recover a success fee in respect of appeals to the Court of Appeal and Supreme Court, but under a CFA that she had entered into before the first instance trial. I rely on it simply for what Lord Sumption says. Paragraph 17 on page 234, just by little g, he identified the question. Critical question is whether the 2 appeals constituted part of the same proceedings as the trial or distinct proceedings, as Paragon argues. And then over at paragraph 19 on the next page, however, proceedings is not a defined term in the legislation, nor is a term of art under the general law. Its meaning must depend on its statutory context and on the underlying purpose of the provision in which it appears, so far as that can be discerned. And there's also a statement to similar effect in the Court of Appeal case Hawksford Trustees and Stella, authorities tab 14. A similar question to the one that arose in Perrett. This time it's about recoverability of an ATE policy and whether a trial and an appeal were separate proceedings or part of the same proceedings for the purposes of the Access Justice Act 1999, section 29. And I rely on it simply for what Lord Justice Etherton says at paragraph 61 on page 195. We're concerned with the meaning of the phrases in any proceedings and in those proceedings in section 29. The word proceedings in the context of court proceedings is a word of uncertain meaning. It can sometimes mean part of court proceedings, such as being limited to proceedings at first instance or to appeal proceedings, or it can mean the entire course of proceedings from inception to final conclusion. Again, not the issue we're dealing with here in this case, but it's simply a general recognition that the term is an uncertain and changing one, and you have to look at the statutory context. So when you come to deciding what proceedings means in this case, I invite you to start, like His Honour Judge Salmon did, with the County Court Act 1984. He's absolutely right to say that's the starting point, and the claimant's absolutely wrong to say that you start with the CPR. It's the 1984 Act that's foundational, that's what defines the County Court's powers. Then one looks to the rules that sit beneath that Act and decide whether those rules cut down or qualify how those statutory powers are to be used, and you interpret the rules in light of the governing legislation. So if we go to the Act at tab 31, there's a definition section which you've already been taken to on page 613. Mr. Hurst took you there to show you the definition of action, which, as he says, means any proceedings in a county court which may be commenced as prescribed by plant. Same thing as a claim form, we accept that. But proceedings themselves are defined non-exhaustively at page 614. Proceedings includes both actions and matters. So if an action is commenced as prescribed, it's a form of proceedings. If a matter is commenced as prescribed, it's a form of proceedings. but there can be proceedings that are neither one of those things. And that's very neatly illustrated by an earlier section of the Act, section 42. Which is back on page 609 in the bundle. This is about when the court can or must transfer matters to the High Court. And 42.1 says, where the county court is satisfied that any proceedings before it are required by any provision of a kind mentioned in subsection 7 to be in the High Court, it shall order the transfer of the proceedings to the High Court or strike them out. 42.7 says the provisions referred to in subsection 1, any made under section 1 of the Courts and Legal Service Act 1990 or by or under any other enactment. Courts and Legal Services Act 1990 prescribes certain things like trust matters, company matters and so on that have to be brought in the High Court. Under any other enactment, that includes this enactment itself, and this enactment, as we've already seen from section 15, says the county court doesn't have jurisdiction to try matters of libel and slander unless the parties consent in writing. And that's then replicated in the rules, because we know as prescribed means as prescribed in the rules. If you look at CPR 7.1, page 376 in the White Book, restrictions on where proceedings may be started are set out in the relevant practice direction supplementing this part. And then you go on to the practice direction at page 393 in the bundle, paragraph 2.9. The following proceedings may not be started in the county court unless the parties have agreed otherwise in writing. And the first of those is a claim for damages or other remedies for libel or slander. So section 42 is expressly addressing a situation where an action has not been commenced as prescribed. It's addressing the situation where someone has wrongly issued a claim form in the county court for something like libel or slander. And it's telling the court what it should do in that situation. But what's notable is that in section 42.1, it's still referring to that wrongly issued action as proceedings, where the county court is satisfied that any proceedings before it are required to be issued in the High Court, etc. So that's a nice, neat example, we say, illustrating that proceedings, as that term is used in the County Court Act, is not limited to actions properly commenced under the rules. It includes anything that we say that is brought before the court in its judicial capacity.
I'm sorry, I missed a step in the middle of your submission there in relation to which part of the rule excludes libel or slander, which was... You referred to...
Section 15 of the Act excludes it, and then one, because one then has to find out whether it's prescribed or prescribed by the rules, then one goes to CPR 7.1, which then takes you to practice direction at 7A, paragraph 2.9.
Yeah, you too. 2.9.
Thank you.
There it is. Thank you.
So proceedings, as that term is used in this Act, does not have the narrow and exhaustive definition that Mr. Hurst invites you to ascribe to it. What does the term mean then? We say we can't really put it better than His Honour Judge Salmon himself. In the core bundle, at tab 6, at paragraph 21 on page 76, he first of all approaches it from a common sense, instinctive point of view. The question, therefore, is in this case, are there or have there been proceedings before the county court? A layperson looking at the word proceeding would obviously say yes. Tenants paid a fee, issued a court form, the court's listed the matter for hearing, court's heard from both sides, the court has made orders. Therefore, there are proceedings before the court, even if they were commenced in the wrong format. And then, having worked his way through the rules and authorities, he comes back and confirms that common sense analysis as a legal analysis in paragraph 46. 46C, the fact that the court has an ability to grant injunctive relief prior to the issue of a Part 7 or Part 8 claim illustrates that any proceedings in Section 38 covers an invocation of the court to grant relief where no Part 7 or Part 8 claim has actually been occurred. The fact one may be issued in future does not invalidate the fact that the earlier order is made in, quotes, proceedings. It supports the proposition that proceedings should be given their ordinary meaning, which in the context of a court, that means any course of action that a party is taking to get the court to grant them a remedy.
I'm so sorry, I thought you said paragraph 46.
46C I'm reading from on page 83.
Thank you.
Then the fact that the process might be flawed or done the wrong way, e.g. without issuing an N208, does not negate the fact that there were proceedings. It simply means there were proceedings brought in an inappropriate form, which of course might have consequences, not that there were no proceedings. And he returns to that theme over the page in E, having referred to the case about bailiffs that he turned up. Says that case supports the proposition that if you seek through whatever means that you ask the court to provide some form of relief, and you seek to invoke the jurisdiction of the court to give you relief, then there are proceedings before the court. We say that's absolutely right. At some point, there must be a boundary between purely administrative acts that court staff do and case where the court's acting in its judicial rather than administrative capacity. You don't need for this appeal to define where that line is, plainly with the right side of it. Application issued, application heard before a judge, both parties addressing the court, claimant first of all asking for a remedy, and then the defendant asking for remedies when she makes her application. On any view, that those are proceedings, and there's nothing in the County Court Act to suggest that they shouldn't be regarded as proceedings. Coming then to my fourth heading, the civil procedure rules. They don't, and we say couldn't, change the meaning of proceedings as used in the County Courts Act. There's no glossary definition of proceedings in the CPR at all. And we say neither do the rules cut down County Court's broad powers to make the orders that the defendant was seeking by her February 24 application in this case. It is fair to say that the term proceedings is not used consistently throughout the CPR. If we start by looking at Rule 2.1, page 34 in the White Book. It starts by saying, subject to paragraph 2, that these rules apply to all proceedings in the county court. That term, as they're used, can't just mean the things that happen after a claim form has been issued, because the rules themselves are frequently concerned with things that happen before a claim form is issued. One thinks of pre-action applications in a Part 25, pre-action disclosure under CPR 3116, and so on. See also on page 62 in the White Book, practice direction 2C. That's under the heading Starting Proceedings General. And then in the County Court, a claim or application may be started in any County Court hearing centre unless any rule, practice, direction or enactment provides otherwise. So there we've got the idea of starting either a claim or an application, but under the heading Starting Proceedings. Again, we say an indication that proceedings is being used, at least in some places in these rules, in a way that means something more than something that has been started by the issue of a claim form. Then we come on to Rule 7.2. Which you've already been shown, and that says, of course, proceedings are started when the court issues a claim form at the request of the claimant. But we say it's clear there that proceedings is being used as a synonym for claim, and not in the wider sense as it's been used in the passages I've shown you previously. That's clear because in the very next paragraph it acknowledges that the court can be seized and make decisions before proceedings are started. But of course, as one sees from section 38 of the County Courts Act, the court can't make any orders unless there are proceedings. Then we come on to CPR 25.2, which in the form that was in last year before these April amendments had a reminder, a reference back to 7.2. That has slipped out of use, but it makes no difference. And again, you can see here proceedings are being used interchangeably with claim, because in 25.21, an order for an interim remedy may be made at any time, including before proceedings are started. But then in 25.22, the court may grant an interim remedy before a claim has been started, only if the matter is urgent, etc. So the claimant's argument is really arguing for too much. If proceedings, that really means only something that happens after a claim form has been issued, then what is the court doing at the pre-issue stage? And what is its power? Because its power is to make orders in proceedings. If he accepts it can make the orders, as he must, because courts make pre-action orders all the time. But if that's so, they must be doing so in the course of proceedings, because that's what section 38 of the Act says. There's an authority that's actually relied on by the claimant, but it's instructive on this and it's supportive of our position. That's the Hayes and Hack case in tab 25 of the authorities bundle.
And indeed, my hearing's not terribly good, and just every now and then I'm losing you.
I beg your pardon.
That's right.
I'll keep my voice up.
You're in tab.
I'm in tab 25 in the authorities bundle. This was an application made for an injunction before issue of a claim form, and in which Mr. Justice Johnson found that the criteria for granting such an application pre-claim form were not made out. he sets out the CPR limitations on pre-claim injunctions at paragraph 32. Notice there he says that there is a power to grant an interim remedy before a claim has started. He looks at the two possible routes, urgency or otherwise desirable in the interest of justice, and he says that neither of those routes are open on the facts of this case. It's perhaps only of passing interest, but he then goes on, nevertheless, to refer to what's going on before him at this hearing as proceedings. We see it at paragraph 51. Miss Hayes, the applicant in the present proceedings, sought an interim mandatory injunction. So he's referring to what's going on in court before the issue of a claim form as proceedings. We say that's absolutely right, but what else are they? The claimant's arguments to the contrary of our case appears to be that the court does have jurisdiction and power to make an interim injunction, but Mr. Hurst says that's not a once and for all jurisdiction, but a limited one. We don't recognise that distinction. We say the jurisdiction is there once the court is seized, but there's then a question about whether the court should be exercising its powers in the absence of a claim form. Plainly, if a claimant gets an urgent interim injunction, doesn't issue the claim form as he wishes, and then starts going to court asking for the matter to be progressed, asking for orders for disclosure or exchange of witness statements, etc., the court's going to say no. The court's going to say, I'm not going to do any of that until a claim form has been issued, and therefore, although you're before me, I'm not going to use my powers in your favour. In support of his suggestion that there's some sort of limited jurisdiction that then lapses or ceases, the claimant cites two judgments of Lord Sumption, the Barton Wright Hassel case and the Cameron Liverpool case. You've already seen the relevant parts, so I won't take you through them again, but just to repeat what Lord Sumption says at paragraph 8 in the Barton case is this: although the court may dispense with service altogether or make interlocutory orders before it has happened if necessary, as a general rule, that service of originating process is the act by which the defendant is subjected to the court's jurisdiction. So he's setting out a general principle and accepting that there are exceptions to it in which the court can exercise its powers in a litigant's favour even before a claim form. And then again in the Cameron and Liverpool case, again there's much discussion in that case about the normal position and the primacy of service of a claim form in civil litigation generally. But again, Lord Sumption says the court may grant interim relief before the proceedings have been served or even issued, but that is an emergency jurisdiction which is both provisional and strictly conditional. Now we accept that, of course, but we say that's a statement about when the court should exercise the jurisdiction that it has in a strict sense, provisional and conditional, because ordinarily it shouldn't be exercising its powers until a claim form has been issued and served. That doesn't mean it can't do so, and it doesn't mean it's not hearing proceedings or exercising jurisdictional powers that are open to it when it does so and when it's appropriate to do so. So just to recap before I come on to the next topic, this is where we've reached so far in my analysis, if you follow me. There were proceedings on foot within the meaning of the Contempt of Court Act County Courts Act 1984, which is what matters. because the court was seized of an issue at which it was required to determine in its judicial capacity. Seized twice over, in effect. Seized by the claimant the first time when he sought his injunction, seized when my client made her application in February 2024, asking the court to use its powers to do something. The court had jurisdiction in the strict sense, in the sense that's explained in Fourie and Leroux. The court could therefore make all the orders that a high court could make because of its powers under Section 38 of the 1984 Act. It's only a general rule the court shouldn't make orders until a claim form is served. There's no specific restriction on it doing so in the rules that could be relevant to this case. That means that it's something that has to be determined by reference to the overriding objective. And that takes me back to the characterisation of my client's application. The orders sought in that February application are strictly limited and ancillary to the wrongful grant of the injunction. They are, as I've said, aimed at undoing the injustice caused by the claimant's actions. And we see no rule or logic to support the defendant's position that it was open to the court to do some of those things, but not all of those things. The claimant accepts that it was open to the court to use its powers to discharge the injunction. But why he stops there and doesn't want to admit the court had power to order costs or to deal with the application for damages caused in breach of the undertaking, it's simply not explained. And we can see from a couple of authorities that the court does indeed have power to make those sorts of orders. First one is Gray and UVW. That's at tab 11 in the authorities. This was a case where an urgent injunction was granted and contrary to what should have happened, that no claim form was then issued. The order recited the undertaking by the claimant to do so, but they didn't comply with that undertaking. Paragraph 66 on page 149, Mr. Justice Tugendhat says this, that where there has been a breach of an undertaking to the court, or a breach of the legal representative's duties to see that correct legal procedures and forms are used, that there must be an investigation by the court, an explanation must be provided. That if the explanation is inadequate, that then sanctions must follow. So that's recognition that in this situation, the court has powers that it can exercise. And further confirmation that the court can act in this situation comes from the law on cross undertakings as to damages. Now I recognise that this is an issue that this isn't an issue that you have to resolve in this appeal as to whether there is an implied cross undertaking as to damages, or whether the court should exercise its powers to write one in. But the point I'm making is that it's recognised in the authorities that the court does have the power to write in after the event a recognition on the face of the order that there was an undertaking as to damages. I hope you've received, I think it came in yesterday, a small clip of extracts from G on commercial injunctions. I'm sorry that wasn't...
Supplementary authorities, G on commercial injunctions.
Yes, and it's the passage that Lord Justice Lewison himself mentions in the grant of permission to appeal. and it's really just paragraphs 1134 and 1135 I need to take you to.
Mr. Hurst, you've had these, I presume.
Yes.
1134.
1134 on page 14.
Thank you.
So there the authors are saying, and they cite authority in support, that whenever the court grants an injunction, unless the contrary is expressly said, the applicant will be taken to have given the usual undertakings and damages by implication. And then at the beginning of the next paragraph, if through inadvertence or otherwise the undertakings are not included, that the order can be corrected either under CPR at Rule 40.12 or under the inherent jurisdiction of the court.
In your skeleton at paragraph 58,
Yes.
you deal with this and you cite SmithKline, which is in the bundle.
Yes.
I had a fairly quick look at SmithKline, and I couldn't identify the passage that you might be relying on.
No, you have to delve quite deep into it because
Well, I didn't.
the court there cites a decision by Mr. Justice Laddie in another case from which you derive the proposition that we make there.
Can you give us the paragraph number that we should be looking at?
Yes, of course. Yeah, so it's at tab 9. And yes, it really turns to the point from paragraph 26 onwards, and then sideline paragraphs are 31 and 32.
26, did you say?
26. Then you get the quote from the Laddie decision at
Right, yes, at D on paragraph 30.
yeah.
It's referring to Laddie. Don't read his observation as suggesting court can impose cross undertaking on a party unwilling to give it, merely that it's implicit in an application, that a cross undertaking will be given. Is that the part you wanted us to?
Yes, and then 31 and 32 as well. The reason we handed in the G extracts is because it's just a little bit easier to get those propositions from what the authors say. On page 8.
Given that we're not going down the fascinating route of whether or not there were or not implied undertakings, where does that take us in?
It simply
appeal?
illustrates that the court, whether or not there are implied undertakings, whether or not they ought to be written in, that the court has power to consider those matters.
Yep.
But once an injunction has been granted. I don't take any further than that, but it's just an illustration that the court has powers in the situation when Mr. Hurst is telling us the court doesn't have powers.
Thank you.
What would happen to the implied undertaking if the appellant was correct and these moving of the court by the appellant was a nullity?
Well, everything would be a nullity, one imagines. The order was...
Because you might give an undertaking to the court that in the event of the order being made, it's probably not necessary for us today, but I suppose it depends on the terms of the undertaking. if you to undertake to indemnify against damage caused by the making of what turns out to be a nullity, it'd still be operative.
Yes, it would be. It would be a promise that
Anyway,
claim was made to the
as
court.
I've just been reminded, we don't have to decide that.
We don't.
I think we've got enough to decide.
But the
But I
point,
take your point that you're relying on it not as a to explore the concept, but to as a further indication that the proceedings are there, and that subsequent orders can be made.
yes, but my client's made
Ancillary orders, I think we
a
term.
limited application for ancillary orders, and here are two cases or a case in a textbook explaining that at least the court has the power to deal with those.
Yep.
However it deals with them in due course is another matter, but
Got it.
that we say explodes the point being made by the claimant that powers somehow come to an end or evaporate. That then takes me on to my fifth heading, which is just
Pre-action costs.
dealing with the cases on pre-action costs. The power to award costs is conferred directly on both the High Court and the County Court by Section 51 of the Senior Courts Act. And also, as we'll see, at least the High Court has an inherent power to award costs even outside Section 51. But if we can just look at Section 51 first of all, it's in the authorities bundle at tab 32, page 621. And Section 51(1), subject to provisions of this or any other enactment and to rules of court, the costs of and incidental to all proceedings in, among others, the County Court shall be in the discretion of the court. And then subsection 4, subsections 1 and 2, the proceedings includes the administration of estates and trusts. So rather like the definition section in the County Courts Act, telling you what proceedings includes but not what it excludes. Then if you look to the rules of court, CPR 44.26.
Sorry, 44 points.
44.2(6) on page 1364. Sets out the various situations in which cost orders can be made. And 6D includes costs incurred before proceedings have begun. There's also a regime for costs-only proceedings recognised in CPR 46.14. Just give you the page in a moment. Page 1568. Again, affected the court's power to award costs incurred prior to the issue or service of a claim form. And if one goes back to Rule 46.1, page 1539, that's the special cost rules dealing with pre-commencement disclosure, among other things. So that's for costs when an application is made under CPR 3116. And the usual order in those cases is that the applicant pays the respondent's costs. So that's a recognition that proceedings in this context include applications that are determined before the issue of a claim form, because of course that's what happens in 3116, and there may never be a claim in a 3116 case because the evidence that the respondent may disclose pursuant to it may show that they're a completely innocent party and the claimant's pursuing the wrong person. So yet again, we see, for example, in the claimant skeleton at paragraph 20, the exploitation of this ambiguity between the words jurisdiction and the words proceeding. It's simply not the case that the claimant must have issued a claim form before the court can make a costs order. It does it in a 3116 case, and it happens in an on-notice injunction hearing that is heard before the issue of a claim and the application fails. Now those cases are quite rare because usually if it's so urgent that the claimant has to get to court and argue their injunction case before issuing a claim form, it will usually be an ex parte case where the defendant hasn't attended. The only case in the bundle like that is the Hazen Park case, the Mr. Justice Johnson decision we were looking at earlier, where he does hear an inter partes pre-claim form application. Unfortunately, one can't tell from that judgment what he did on costs. It doesn't refer to costs. But we say what would happen in those cases is the defendant, having turned up and successfully resisted the grant of an interim injunction, would be entitled in the normal way to their costs of having come to court and doing so. So coming then to the cases relied upon by the claimant, the surprising proposition that the court has no power to make costs orders unless a claim form has been issued. The first is Citation Ellis case. It's tab 13 in the authorities. What's important to understand about this case is that it was a post-claim form case, which was then struck out as a Jamil abuse. And the parties' different submissions on costs are in paragraph 3 and 4. Both of them seem to have accepted that the court could, in those circumstances, make an order covering the pre-action costs. But nevertheless, Mr. Justice Tugendhat was concerned about identifying his powers to do so. Having looked at the authorities, he gives his summary of his understanding of the law at paragraph 16. He says, in summary, I take the law to be, if no claim form is issued, then there is no litigation, so there are no costs of litigation, whatever costs may have been incurred in complying with a pre-action protocol. But 2, if a claim form is issued, the costs incurred in complying with a pre-action protocol may be recoverable. Now, the first of those 2 propositions is clearly obiter. It just didn't arise in this case because it was a post-claim form case. And we say that it's simply wrong.
And what is wrong is if no claim form is issued.
Yes.
So if you said if a claim is intimated but not pursued to court, to any court involvement, then there's no litigation
Yes, that-
for the purposes of that statement of principle.
That would be a better formulation, yes,
Yeah.
that would be the correct formulation. And the next case we were shown was web resolutions at 16 in the bundle. And again, you see from paragraphs 1 and 2, this is another post-claim form case. The claim form has been issued. But then there's an attempt to recover some pre-action costs. And it's effectively, from paragraphs 32 onwards, it adopts what is said by Mr. Justice Cobb. In fact, I should take you back to paragraph 20 through to 22, first of all. But what the Deputy Master does there is divide up section 51 costs orders into different phases. He says that phase 1 is where there's a dispute, parties incur costs which would be recoverable as pre-action costs if a claim form is issued, but the potential claimant decides not to issue a claim form. At phase 2, where a claim form is issued but not served, and phase 3, where a claim form is both issued and served, but the claimant doesn't take any steps in the claim. That's not an exhaustive definition of the situations which might have to be encountered. Clearly, the Master doesn't have in mind the situation that arises in this case, where the court has been seized at the pre-action stage and things go no further. So again, we say that once one understands the facts of that case, it can't be authority for the proposition that Mr. Hurst advances. And then lastly, there's the Stubbins case at tab 29 in the authorities bundle. This was a case in which proceedings were issued, but the claim form was then amended prior to service, not needing the court's permission, of course, to remove certain allegations. The defendants subsequently sought costs, including some pre-action costs of dealing with those abandoned allegations, and the defendants advanced their case by analogy with the rules on discontinuance. You see that from paragraph 1 and from an explanation of chronology at paragraphs 9 through to 11. Although they're not sidelined, I think it's paragraphs 34 through to 37 that Mr. Hurst was relying upon. And again, it's consistent with a citation Ellis type analysis that somehow the service of the claim form is the threshold after which costs become within the powers of the court to order. But again, it's not on point on the facts, and it doesn't advance the legal propositions any further. So we say, properly analysed, none of these, the cases that Mr. Hurst cites for his proposition that power to award costs only occurs after claim form is issued, are correct. But lastly on this point, it's worth looking at the Associated Newspapers and Impact case, which is at tab 5 in the bundle, because I think this is probably a nice illustration of the distinction that Lord Justice Stuart-Smith was proposing to me as an alternative statement of the principle in Ellis and citation. Facts in this case were as follows. The defendant was a company that had acquired intellectual property rights in respect of someone called Michael Stackpool, who is someone who it seems had information that in relation to Geoffrey Archer that may have been of interest to the media. And the defendant company had obtained those rights pursuant to an agreement they signed with Mr. Stackpool in 1995. The defendant, on a Friday, got wind that the Mail on Sunday was about to publish an article drawing on Mr. Stackpool's information about Geoffrey Archer, and it made an urgent application for an injunction, its argument being that these were its intellectual property rights that were being interfered with. It's not clear whether an application notice was actually ever formally issued. Probably not, because it was a Friday night injunction. But a duty judge is lined up for the next day to hear the application on the Saturday morning. Meanwhile, the Mail on Sunday provides evidence to the defendant that in fact its story is based on information supplied by Mr. Stackpool in 1994, prior to him doing a deal with the defendants in 1995. And the defendant, faced with that information, effectively withdraws the application, as the authority says, at the door of the court. Associated Newspapers then brings a claim for its costs. And the judge, Master Turner, considered it first as a Section 51 case, and then as a case concerning the court's inherent powers as to costs. At paragraph 14, he identifies those two possible routes for an award of costs. At paragraph 15, he says that Section 51 isn't open because there's been no claim form issued. So that's the Tugendhat line of reasoning. And we don't consider it's right, because we say proceedings in Section 51 is wide enough to include this situation. He probably was right to say there were no proceedings in this case, because it stops at the door of the court. The court is never actually seized and required to make a decision. So he's probably right on the facts that Section 51 didn't apply to these facts. We say that when you step through the door of the court, as happened in this case, and the court is seized and required to start making judicial decisions, that those are proceedings both within Section 38 of the 1984 Act and within Section 51 of the Senior Courts Act. Having rejected that route, he then goes on to find that nevertheless in that situation the court had an inherent power to order costs, and he says that that is the right course to take on the facts of that case, where a party's been dragged right to the door of the court and left there having run up costs. But as I say, we don't need to take you down that inherent powers route, because we say we're firmly within Section 51 once the term proceedings in Section 51 is given its proper definition. But again, if you're against me on that, we still have the High Court with its inherent powers to make costs orders. Then you go to Section 38 of the County Court Act, saying that County Court has the same powers as the High Court, and so you can get through it to that route as well. So before I hand over to Mr. Mitchell, just to summarise where we've got to, once you clarify the ambiguous terminology, the common sense position that the court should be in a position to remedy the injustice caused by the claimant's abuse of procedure is also shown to be the true legal position. Both District Judge Khan and Deputy District Judge Robinson had jurisdiction in the true sense, the for in lieu sense, that there were proceedings within the meaning of the 1984 Act, proceedings within the meaning of Section 51 of the Supreme Court Act, and nothing in the CPR precludes the court from exercising its jurisdiction in the way that the defendant was asking it to. On the contrary, it would be entirely consistent with the CPR because the CPR required a claim form to be issued. It required an undertaking, as a cross undertaking in damages to be included, and the result of a claimant not having followed the correct procedure plainly gives rise to proper issues to be tried about the incidence of costs and damages incurred by my client, which it's in accordance with the overriding objective to hear and determine. So unless I can insist any further, those are my submissions on those first 5 issues, and I'll hand over to Mr. Mitchell to deal with the alternative case.
No, thank you very much.
Do you want to come here?
Yes, Mr. Mitchell.
My lady, my lords, the alternative ground was within the judgment of His Honour Judge Salmon at paragraphs 48 to 68, and if I could ask you please, before turning up those paragraphs, just to open up tab 6 of the core bundle, and if we look briefly at the start of the judgment, because it's important, it's critical in my submission that one looks at the extraordinary and highly peculiar facts of this case, which was the basis on which His Honour exercised his discretionary power under CPR 3.10. The point's an important one because contrary to what has been said by Mr. Hurst, this case isn't of any wider application. It is specifically confined to the extraordinary facts within its 4 corners. So turning to the judge's findings, we see at paragraph 6, this is on page 71, that in terms of the N16A application form, which Mr. Eardley took you to earlier, it's at the start of the supplementary bundle, that the box was ticked indicating that the application was brought by way of the Protection from Harassment Act, further ticked the box which indicated it proceeded by way of a Part 8 claim. The fee for a Part 8 claim was at the time £332. Payment was made by the appellant of that court fee. The prescribed form has at the bottom of the form to be completed by the court. Court completed that form, indicating that there would be a hearing that was to take place on the 3rd of August 2023. I draw the court's reference to that because we'll go on to look at how His Honour Judge Salmon approached the question of whether or not the form complied with what Part 8 says regarding the rules and the contents of a Part 8 claim form. Turning over the page to paragraph 12, page 72, and I think it's 4 lines down, you'll see the section, it was suggested to me. Now, if we just follow that through, and I'll read through to the point, there's a bit that's been missed in the transcription, but RPC and myself had the same note of it. I'll come to it in due course. The passage reads, it was suggested to me that a proper reading of the correspondence was that the appellant solicitors were always aware that proceedings should be started by the use of an N208 form rather than form N16A. I disagree. It's clear that either the appellant solicitors thought that they had started proceedings with the N16A form or, and this is the bit that's been missed, our note is, and I make it clear, I make no finding, were malevolent in the deliberate use of the wrong form. And that section to do with possible malevolence, no express finding, is what the judge later refers to at the end of that paragraph, where in the final sentence he says, "I make no factual findings that this was a deliberate ploy in the hope a district judge might grant relief where in my judgment a high court judge would not." I emphasise that passage because that was the judge below, that was his finding, having gone through all the documents. Of course, there was no evidence from Mr. Statue, the solicitor. Mr. Statue hasn't attended in person any of the hearings in these proceedings, and it hasn't attended in person at court today. But nonetheless, his client, Mr. Gotti, is fixed with that finding, and it isn't open to for him to say, as he does through counsel in these proceedings, and this is Mr. Hurst's paragraph 48 of his skeleton argument, quote, that Mr. Statue well knew that an N208 should be filed, that there has been no evidence, at least witness evidence to that effect, and it's contrary to the finding of His Honour Judge Salmon. If we turn then to the alternative ground and how it was dealt with by the circuit judge, this begins at paragraph 48, it's on page 84. If we look just briefly at paragraph 61, that's at page 89. Having considered the Ealing against persons unknown case, the judge correctly directs himself in the second sentence there. It seems to me the fundamental question for a court when considering whether to exercise a discretion under 3.10 is whether or not the court can use that rule to validate a claim form issued in the wrong form. That was the issue below, and it's the issue on appeal. And we say unarguably the decision that was reached by the judge based on the extraordinary facts before him was correct and is not susceptible to challenge before this court. Before coming on to our submissions concerning why there was no error, by way of summary of the discretionary power at CPR 3.10, we made 5 general points, some of which have been touched on by Mr. Hurst this morning in his consideration of CPR 3.10. The first point is this, that as stated by the rule itself, it's concerned with situations where there has been an error of procedure, such as a failure to comply with a rule or a practice direction. It's uncontentious that a party is not entitled to rely on the general power to circumvent conditions which are set out elsewhere in the rules, and that is the central point that all of the authorities you were taken to this morning are concerned with. A recurrent theme in these authorities is the inability of a claimant who hasn't complied with the rules on service to circumvent those rules by making an application under 3.10, and effectively that is impermissible because it renders obsolete the operation of the rules on service, as the authorities say. Within the authorities, a distinction is drawn between committing an error when following a procedural step, which can be remedied. So, for example, the case of Steele and Mooney, which crops up repeatedly in the authorities, was the case where an application was made to serve particulars of claim. There was an application for an extension of time to serve particulars of claim, but the application itself omitted to seek the extension in respect of service of the claim form. And it was said that that was something by this court which could be remedied. That's to be contrasted with the situation where a litigant doesn't take a procedural step at all, which falls outside CPR 3.10, and the case which is off-cited in all the authorities, and Mr. Hurst has referred to Venos and Marks and Spencer, a case where an issued claim form was not served in time. It was served late, 9 days after the period for valid service had expired, the application to extend time for service didn't comply with CPR 7.63, the various conditions, and therefore CPR 3.10 did not avail the claimant, all of which is uncontentious. The third point we make is that if, however, the rule is engaged, as it was in this case, then the court's discretionary power under 3.10 is a beneficial provision which is to be given very wide effect. So much is clear from the wording of the rule itself, which is framed in the broadest possible terms, quote, general power of the court to rectify matters where there has been an error of procedure. The fourth point we make is that the exercise of the power doesn't require an application by a party. There wasn't an application by the defendant in this case. And that, of course, is to be contrasted with the anterior rule at CPR 3.9 concerning relief from sanctions. CPR 3.10 can be exercised by the court on its own motion, as happened in this case. And that, we say, only goes to illustrate its breadth, because, of course, the highly unusual, novel facts in this case, unlike all of those authorities that my learned friend puts before the court, where a party who has failed to comply with a procedural step or not comply with the procedural step at all seeks the court's indulgence under CPR 3.10. In this case, there was no application. It was a point that was raised by His Honour Judge Salmon himself when granting permission on appeal from Deputy District Judge Robinson. He observed within his reasons for granting permission that on the face of the N16A application form, it contained the contents required by Part 8, and raised the question of whether or not the defendant could otherwise rely on CPR 3.10. And of course, that decision, which he then was supported by the defendant by the time it came to the appeal before him, that was very much in the teeth of the opposition from Mr. Gotti, who continues to dispute the exercise of that power before this court. So again, it is only to emphasise the breadth of the application of the beneficial power once engaged. And the fifth and final point, importantly, is that as the authorities repeatedly state, in its exercise of discretion, the court should not elevate form over substance. That was a point made by Lord Justice Brooke in the case of Hannigan and Hannigan at tab 3. We needn't turn the authority up, but it was mentioned by my learned friend earlier that the reference to form over substance is at paragraphs 20 to 21. But as Mr. Hurst mentioned this morning, the error of procedure in this case, it was an application or a claim by a widow under the Inheritance Provision for Family Independence Act 1975 against the executors of her late husband's will, in which she mistakenly commenced proceedings using the obsolete Form 208 from the County Court rules, since superseded under the CPR by N208 under Part 8. The claim was struck out. The strikeout was upheld on appeal, but was then overturned by this court upon the further appeal of the claimant. And it was said by this court that the county court beneath had erred in the exercise of its discretion, and that this was something that could be remedied by CPR 3.10 because the defendants had all of the information necessary to understand the claim against them. That's at paragraphs 33, 35. That was relied on by His Honour Judge Salmon in the case which we're concerned with today. And another authority of Lord Justice Brooke, shortly after the case of Hannigan, albeit not concerning CPR 3.10, but concerning an application to amend a claim form under CPR 17. That's the case of Thurrock Borough Council and the Secretary of State for Environment, Transport and Regions. It's at tab 4 and it needn't be turned up. We only rely on it for the point that's made by Lord Justice Brooke at paragraph 29, where, relying on his previous judgment in Hannigan, he said, in that case, both the district judge and the circuit judge on appeal had given precedence to form over substance and had struck out the claim because of substantial non-compliance with the rules. This court came to a different conclusion. So, in summary, in terms of how we say CPR 3.10 applies in this case, it's a broad discretionary power. It's flexible in its application, depending on any given facts, which again is illustrated by the highly unusual facts of the present case. Moving on to why we say that there was no error of law by His Honour Judge Salmon, we make 3 points. The first is this, that the N16A application form, which we looked at briefly earlier, it complied with the requirements of Part 8 in terms of its contents, and it was to be treated as a Part 8 claim form for the purpose of other injunction claims under CPR 65. And this is, the judge considered these points at paragraphs 51 to 56 of his judgment. Before coming to the specific issues concerning Part 8 claims in this case, it is instructive in my submission to contrast the position regarding Part 8 and what the rules prescribe in terms of specific forms to that under Part 7. Mr. Eardley earlier looked briefly at Practice Direction 7A. If I can find the reference in the White Book, if I could ask you please to turn in the White Book, it's page 392. Now, the rule itself, CPR 7, does not prescribe any specific form by way of a claim form, but we do have the prescription within the practice direction. So, for instance, if we look at page 393, paragraph 3.1, the claim form, a claimant must use form N1 to start a claim under Part 7. And then further, if we turn over the page at, we see on 394, starting a Part 7 claim in the County Court, paragraph 5.1 is again set out there that the relevant form is a mandatory use, is form N1. And again at 5.2, in proceedings referred to in para 4A.1, the claimant must specify the preferred hearing centre on the form N1. So Part 7 does not admit of any exceptions. A Part 7 claim has to be brought by way of an M1 claim form, regardless of whether the claim is proceeding in the County Court or the High Court. If we contrast that with the position under Part 8 and look at page 411 of the White Book, whereas there is a statement there, contents of the claim form, setting out what information the claim form must include, there isn't any particular form mandated. Now, it is said in the commentary at 8.21, claims to which Part 8 apply are commonly commenced by issue of Part 8 claim form N208. And then in the next paragraph, or a few lines down, a Part 8 claim form must be in practice form 208. Now, that cannot be right because of what Mr. Hurst has already taken you to regarding the practice direction to Part 65, which is what His Honour Judge Salmon was interested in, namely the fact that other types of claims for injunctions under Part 65 are expressly required to be brought, not by way of an N208, but by way of an N116A. So that's the contrast between Part 7 and 8. The analysis of the judge below, he'd set it out in his order granting permission, and he repeated it in the judgment at the end of the hearing, is that the constituent parts of the content required by Rule 8.2 were on the face of it included in the N16A claim form, with the exception of the statement of truth, because 8.2 requires a statement that Part 8 applies. That was set on the face of the injunction application. Remedy, which the claimant is seeking, legal basis for the claim to that remedy. Well, it said that he was seeking an injunction under the Protection from Harassment Act 1997. Claim has been made under an enactment, what the enactment is, Protection from Harassment Act 97. And then at the end, in parenthesis, at the bottom of 8.2, Part 22 provides for the claim form to be verified by a statement of truth. Well, the fact that there wasn't a statement of truth on this application notice is not an insuperable obstacle to it being treated as a Part 8 claim for the two reasons that the judge identified. Firstly, pursuant to CPR 22, the fact that a statement of case isn't verified by a statement of truth doesn't invalidate the statement of case, but it leaves it susceptible to strikeout. Namely, it still has status, notwithstanding the absence of the statement of truth. And more importantly is the point which I've just referred to, the fact that elsewhere in Part 65, it is mandatory that claims for injunctions are brought by way of the claim form that Mr. Gotti relied on in this case. Of course, he should have brought his application by way of a general, he should have brought the Part 8 claim separately under the rules. But one can forgive his confusion if it was that, given the way that the practice direction is set out, and we've looked at this already, it's page 2249, issuing the claim 1.1, an application for an injunction under Chapter 3 of Part 5 of the 1996 Act, that being the Housing Act 96, Part 4 of the Police and Crime Act 2009, or Part 1 of the Anti-Behaviour, Crime and Policing Act 2014, must be by form N16A. And for the purposes of applying Part 8 to applications under Section 1 or Section 8 of Part 65, form N16A shall be treated as the Part 8 claim form. Now, the judge considered, and this was his paragraph 54, he considered that this might have been the misunderstanding on the part of Mr. Gotti's solicitor, Mr. Statue, because as he said at his paragraph 54, it may be that the confusion caused the appellant solicitors to use form N16A. I pause to note that this is not the first time this court has seen protection from harassment injunctions applied for using form N16A. And then 2 paragraphs later, paragraph 56, I won't read it out, but that is the judge's analysis of how the N16A claim form complies with the requirement to do with information contained in a Part 8 claim that we see at CPR 8.2. And we say unarguably the judge is correct in respect of his analysis. Now,
we've looked at CPR Rule 8.2. There's nothing there about the date of the application.
No.
That, of course, is relied upon by the appellant as of some significance.
yes.
If we look at a bit further in the rule, we see that the requirement for service by a particular date is indeed provided for. So what do you say about that?
Well, the way that the judge approached this issue, because it is a point that Mr. Hurst raised below, is his paragraph 64, and he approached it in terms of limitation. And if you see his paragraph 64, we said, how would anyone know that the claim was issued? Well, the answer to that is straightforward. When the court issued, it did so with the date, 19th of July. Of course, for limitation purposes, it's not the date of issue, but the date of receipt that counts. Whilst I accept that in this case, the court erroneously did not appear to have stamped the date received of the letter of 5th of July, they should have done, and it's normal practice, and therefore one can assume that for limitation purposes, that is not an issue. So in terms of the point, my lord, is that the form itself on the judge's reading complies with what part 8.2 says, and the point to do with limitation, as I understand it, there are two facets to this, neither of which apply in this case, and they're to do with the bright line rule as it's referred to in the authorities, namely the originating process and how it is that an individual is brought before the court so that the court has jurisdiction over them, the in personam jurisdiction point. That, of course, didn't arise in this case because there was no dispute that Ms. Perrett knew about these proceedings. She'd been served, she'd attended court, she argued admirably and with skill, in my respectful submission, as to why the injunction shouldn't be granted. So she knew exactly what was happening and she was on notice of it. And of course, the other point, and it's the point that Mr. Edley has already referred to by reference to paragraph 8 of the Barton and Wright Hassel case, Lord Sumption, when he's talking about bright lines, he expressly qualifies this by talking about, as a general rule, service of the originating process is the act by which the defendant is subjected to the court's jurisdiction. Obviously, that rule is not in absolute terms because of all of the pre-action jurisdiction cases which we've looked at and the points that have already been made concerning the jurisdiction of the county court under section 38 to make the order pre-issue of a claim form. So all of the N16A claim form, albeit imperfect, it complied with Part 8. It's the form that should be used for other injunction applications brought under Part 65. And the arguments to do with, well, the bright line here doesn't operate because how does a person know that a claim has been brought against them and that they're subject to the jurisdiction of the court? Well, that doesn't apply because Mrs. Perrett had been hauled to court on short notice to be told that an injunction which is now accepted was unlawful was to be made against her. So it was against that background that the judge applied the discretionary power which he had under 3.10. And then the second point we make as to why there was no error by the judge is because His Honour Judge Salmon correctly directed himself to precedent authority, including from this court, where it's been held that 3.10 remedies the use of the wrong form to commence proceedings. I've already addressed Hannigan and Hannigan. My learned friend Mr. Hurst spoke to the case of LD Commodities and the owners or charterers of the Stylania Z. That's the Mr. Justice Tier case at tab 15. The court needn't turn it up, but as Mr. Hurst has already explained, the error here was using an in personam claim form rather than an in rem claim form in admiralty proceedings. And Mr. Justice Tier said that that was something which could be cured by CPR 3.10. He referred to Hannigan and he also referred to Thurrock Borough Council at paragraphs 37 to 42. Importantly, he held that, and this is at paragraph 5011, it's page 211 of the authorities bundle, although you needn't turn it up. The point is this, he said that on the facts of that case, 3.10 was appropriate to further the overriding objective to prevent a party obtaining a windfall which would cause an injustice. And of course, that's exactly how it was applied in this case by His Honour Judge Salmon, who had regard to the authority. It was in the previous version of the White Book, and it's in the current version of the White Book at page 150. And we see His Honour Judge Salmon expressly referring to those points at paragraph 65 of his judgment, where he talks about the merits of applying 3.10. He says, in my judgment, they're overwhelmingly in favour of doing so. The reasons are as follows, and he gives three. One, not to do so would be an unjustified windfall, allowing the appellant who thought they were starting proceedings to escape the consequences of starting such proceedings in the wrong form. Two, all the necessary material is in an N16A as is required, and N20A to set out in CPR 8.2. And then finally, he applies the overriding objective to deal with matters justly. So that is an unsurprising application of LD commodities and Hannigan to the facts of this case, which was perfectly within the discretion of the judge. Just to make a final point on this, it's said by Mr. Hurst at his paragraph 47 that neither Hannigan or LD commodities were should have been applied by the judge, and they're distinguishable on the basis that the claimant had not taken any sort of a procedural step at all. So this is the Venus and Marks and Spencer line of authorities, but of course that ignores the fact that he had issued the application for an injunction and had brought Ms. Perrett before the court. And then the last point we make in terms of why there was no error of law by His Honour Judge Salmon below is by reference to the number of authorities that my learned friend has put before the court, all of which are dealing with different situations because they are concerned with parties who have failed to comply with the rules, typically to do with service, and then seek the court's indulgence to typically circumvent what the rules on service otherwise require. And obviously that wasn't the case here. And that was the point that, because the different authorities, but a number of which are relied on before this court, were put by Mr. Hurst before His Honour Judge Salmon, and the judge distinguished them at his paragraph 60. All of the cases the appellant's counsel have referred me to, bar one, relate to matters where the CPR has separate rules that one must follow in order to correct errors. This is not the case here. The White Book deals in its commentary with a number of cases which are more closer to the position here in terms of cases that have been cited to me, and that was the LD commodities and the Hannigan case. And in his submissions this morning, Mr. Hurst said, and my note of it is as follows, that the effect of the judge's order, to quote, in effect, it was an order for alternative service under CPR 6.15. Of course it wasn't, because service wasn't an issue in this case. It was simply an order by which the N16A application form was treated as a Part 8 claim form. So to briefly, a few brief points about the authorities that Mr. Hurst relies on, and the court needn't turn up any of the authorities bundle. Just by way of summary, the first, the tab 8, Ossia Road campsites, the Mr. Justice Pumphrey case to do with Jeremy Bamber. Of course, CPR 3.10 did not avail Mr. Bamber because the Companies Act prescribed that a petition had to be brought by way of a certain form. So he wasn't able to bypass that statutory requirement. That obviously isn't the facts of this case. And then in terms of, I won't speak to Barton and Wright Hassel, we've already heard about that. The tab 20, the Mrs. Justice O'Farrell case, Boxwood Leisure, Gleeson Constructions. This is a non-service point. CPR 3.10 cannot avail where there hasn't been compliance with rules to do with service. Hannigan and Hannigan LD Commodities weren't before the court because, of course, they dealt with different facts. And then tab 23, London Borough of Ealing and persons unknown, the Mr. Justice Nicklin traveller case. The defect here was, as Mr. Hurst has pointed out, that the applicants for the injunction did not seek an order for alternative service when they went before Mr. Justice Nicklin on an urgent basis, and it was said, unsurprisingly, sorry, they went before a different judge, but it was said by Mr. Justice Nicklin that this was a failure to comply with CPR 6.15. It didn't fall within the ambit of 3.10. Again, that is uncontroversial. It doesn't deal with the facts of this case. Tab 24, the Good Law Project case. Again, this is failure to serve in time. 3.10 doesn't apply. Hannigan and Hannigan LD Commodities were not referred to the court because they deal with a different point, the point in our case. And then similarly, tab 26, Ideal Shopping and MasterCard. Again, CPR 3.10 did not validate service to do with an unsealed amended claim forms which had been served. Failure to comply with the rules, 6.15 or 6.16. It's not a CPR 3.10 case. Hannigan wasn't referred to the court, nor was LD Commodities because they deal with a different point. And then tab 27, Peterson, Howard, the Walden Estates, the Mr. Justice Eyre case. The failure here was the failure to pay the correct issue fee. And unsurprisingly, his judge said, well, this isn't something that's even required under the rules. So 3.10 isn't something which can be relied upon. So again, no relevance to the present facts. And then finally, the case of Pitalia and NHS England at tab 28, failure to serve claim form within the 4-month time limit at CPR 7.5. And then there's a challenge against jurisdiction, which itself isn't made properly in compliance with CPR 11. But the court said that failure to challenge jurisdiction in the application was something that could be cured under CPR 3.10 because all that the defendant had failed to do was to tick the box in the acknowledgement of service stating that it disputed jurisdiction. So again, it's uncontroversial. It doesn't apply to the facts of this case. So in summary, for the reasons stated, by reference to the close findings of His Honour Judge Salmon, based on the highly unusual facts of this case, his exercise of his discretion under 3.10 was perfectly open to him and it admits of no error.
Anything else? Thank you very much, Mr. Mitchell. Anything in reply?
If I may, some short points. Just to go in reverse order. Lady my lords, the point was made that the point was argued by Mr. Mitchell that the judge was right to apply Hannigan and the commodities case, and that the Steele and Mooney point about not taking a procedural step didn't apply. If I can ask you to just look at page 497 of the bundle, of the supplemental bundle.
supplemental bundle or the authorities bundle?
So this is supplemental bundle, my lord, at 497. And we did see it briefly this morning. It's the response to RPC concerning the failure to serve a claim form. And you'll see that at the end of the paragraph, numbered paragraph 2, Mr. Gotti's solicitor says, for the sake of completeness, we will file and serve N208. That is, in my submission, extremely clear evidence that this is a case of procedural step not taken at all. The second proposition of Mr. Mitchell's, which I would dispute, is the point that the N16A can fulfil the requirements of a Part 8 claim form. And you were shown CPR 8.2, which provides what a claim form must, an N208 claim form must contain. Now, if one were to turn back to the N16, which is at supplemental page 169, one sees that it fulfills some requirements of CPR 8.2, but not the most important. It is about stating what a remedy might look like. It does not, in my submission, engage with CPR 8.2A, B1, the question which the claimant wants the court to decide. That question is contained in sections 1 to 3 of the Protection from Harassment Act. And that question is whether the person moving the court for an injunction can show that there's been a course of conduct which amounts to harassment of others and which the defendant, the respondent, knows or ought to know amounts to harassment of another, which is very much the work of particulars of claim in a harassment claim, and particularly a complicated harassment claim of the sort that was to be run here, where there was a representative issue as to whether Mr. Gotti was representing and protecting the interests of other employees of the medical company. So it is wrong to suppose that CPR, the N16A form could satisfy even remotely, not least the point that Mr. Justice Cobb made about the issue date. Some other short points, a couple of points on the authorities that you were referred to. Thurrock is not going to assist the court at all. It's a very straightforward decision on the amendment of a statement of case once it's been served, applying the amendment powers under CPR 17. What Lord Justice Brooks said in reference to Hannigan is purely obiter, and it doesn't form part of the decision. It's not going to take matters forward. Similarly, impact is problematic. None of the decisions of Sir Robert McGarry or Lord Toulson, none of the law which is cited in the line of costs cases which I took the court to this morning is cited to Master Turner, and in my submission it's impliedly overruled by those line of cases and should be treated with some circumspect. And further back in time to points that were made by Mr. Erdley, what is indeed between the parties to this appeal is the notion that moving the court at the initial stage for an interim injunction is establishing a once and for all jurisdiction. The Fourie and Leroux, and indeed the other cases on interim injunctions which are placed before the court, have to be treated with some caution because of the context of their subject matter. They are cases concerned with freezing injunctions in circumstances where it was necessary to do justice that there would not be substantive proceedings. They are cases concerned with the flexibility of equity to allow the courts, when persons properly before them and served, to give interlocutory injunctive relief, but in circumstances where there may not be or is not a claim between the parties to the application within the jurisdiction, or indeed necessarily within any jurisdiction. And it was these decisions emerge in a very specific context in reaction to the Siskina, which had been a case which limited the ability of the court to make freezing injunctions in circumstances where there were not, where there was not going to be a domestic claim for the monies that were relevant to the freezing order. Therefore, one has to be somewhat cautious with looking at cases from a jurisdiction which are concerned to show that the court has injunctive powers of injunctive relief in any event and irrespective of what follows. That's one point. If also one looks at what you were taken to in Fourie and Leroux, if I can just ask to go back to that very briefly, it's at 10 of the authorities bundle, and taken to paragraph 32 of the decision by Mr. Erdley. In my submission, there's nothing that Lord Scott of Foscott is saying here in this paragraph which cuts across my essential submission that the court may be moved for an interim injunction and it has the jurisdiction in the strict sense to grant it. But that does not answer the question which my case raises, which is that then what in terms of the source and power of the court's jurisdiction? And I believe that's implicit in the way that this paragraph proceeds. For example, Lord Scott says, but it is not in dispute that in suitable circumstances a freezing order may be and often is granted the served on the respondent before substantive proceedings have been instituted. Such an order is not a nullity. It is of immediate effect. If proceedings for substantive relief are not instituted, the freezing order may lapse in accordance with its own terms, or on an application by the respondent may be discharged. But none of this indicates that the court has no jurisdiction to make the order. No activation of the jurisdiction is needed. He's talking about what happened in this case before District Judge Khan, but his comments in my submission are not. The principle here is not going wider than that, and it's not addressing what Mr. Erdley invited the court to take from this, that it is established a once and for all jurisdiction, if I can call it that.
What do you mean by once and for all?
My case, my lord, is obviously that we don't quibble that the court properly see broad idea, see Fourie and Leroux, has the power and the jurisdiction in the strict sense to make the injunction order, and it must be it said my position is on this is inconsistent because we say that it can be discharged, but it must be a natural corollary of the ability, the jurisdiction which is these Supreme Court cases are refining and confirming, if there's the jurisdiction because the parties are properly before the court to make, there must be the jurisdiction to unmake. That goes as night and day. As a corollary, we say, and therefore our position that the court has always had jurisdiction to unmake what it made on the 3rd of August 2023 must be correct. What once and for all, my point of once and for all is that the jurisdiction is a question of stages, and what may have been foundational of jurisdiction for an interim injunction application does not answer the question of whether there are ongoing proceedings, case managed under the CPR with different powers and rules and practice. You heard my submissions on why that's not the case earlier, and just finally to test some propositions, because what I think as litigation lawyers, obviously what looms large in a submission that a court doesn't have jurisdiction, the non-compute is that a matter is before the court. That's the point. That's the affront to common sense in this case. That's what makes it very difficult. But just to test propositions along a spectrum, the cases seem to be.
Just before you go there,
Yeah.
I'm just thinking about your once and for all submission. In this case, the injunction was going to be discharged. You accepted your lay client accepted that it had to be discharged.
Yes.
But I think your case has to be, doesn't it, that if it was going to be contested as to whether or not it should be discharged or not, and the matter came before the court for an oral hearing
Yes.
as to whether it was discharged,
Yes.
and the judge discharged it,
Yes.
or indeed didn't discharge it,
Yes.
your case is that absent a claim form at that stage, in proper form you would say,
Yes.
even though everyone was in court, there'd been a full hearing about whether or not it would be discharged, the judge would not be allowed to make orders for costs at the
Yes.
conclusion of that hearing.
That is my submission, applying the authorities which we've looked at.
Do you? No, sorry.
The spectrum that I was testing was the litigation lawyers would agree that there are no proceedings if there are exchanges of correspondence in the protocol. Litigation lawyers would probably also agree that the mere issue of an application notice didn't amount to proceedings.
It depends what you mean by proceedings.
Well,
If you're talking within the parameters of your assertion that proceedings start with a claim form,
yes.
well, if your litigation lawyer was discussing it in those terms, then he would agree with you. But that's not the point. It's absolutely not the point here.
You have my essential case this morning, but the litigation lawyer, the hypothetical litigation lawyer, would say the mere application, the mere service, correspondence, all of these things before issue of the claim form are not proceedings. I'm submitting that the principles show that stepping into a courtroom doesn't move if the Rubicon is the issue of the claim form, even though that there's been a dispute that's heard in the court, it hasn't amounted to proceedings because these things operate in stages.
Thank you. Anything else? No, thank you very much. Well, thank you all very much, all counsel for the submissions and everyone behind that have assisted with the preparation and organisation of the papers. We're very grateful. They were very nicely presented and easy to manage. You won't be surprised that we're going to reserve our judgment in this rather unusual case. I can't promise you precisely when that judgment will be. But we're conscious, of course, that the people subject to the litigation are anxious about the matter, and it's been going on for a substantial period of time. You'll be sent a draft judgment in the normal way. Please can people remind their lay clients of the terms of the embargo, which we take extremely seriously. I'd hope that, well, then, having received the draft, minor typographical errors or infelicities, please, and not an opportunity to re-argue the case. And then I'd hope everything else can be dealt with on paper. We'll deal with any disputes on paper, and ultimately I'd hope you'd be able to agree in order. So thank you all very much indeed.